In light of the fact that the price of XRP is continuing to rise in Wales, the Chief Executive Officer of Ripple, Brad Garlinghouse, has published an additional statement in which he emphasizes his disagreement with the position that the SEC has adopted regarding cryptocurrency. Despite the fact that a judge has determined that XRP does not meet the eligibility requirements to be classified as a security, Brad Garlinghouse has continued to express his dissatisfaction with the recent actions taken by the Securities and Exchange Commission. Garlinghouse made the following remark, which was a comment that the majority of people believed could not be any lower than it already was or could not be any lower than it already was. There has been a significant amount of controversy that has been sparked within the cryptocurrency market as a direct result of the statements that were made by the CEO. These statements bring attention to the ongoing conflict that exists between Ripple and the government agency. In addition, Garlinghouse mentioned that the Ripple team will be keeping a close eye on the situation and analyzing our options in order to guarantee that the SEC would be held accountable for their conduct. As a result of this remark, one gets the idea that the business is contemplating taking additional legal or strategic actions in reaction to the approach that the Securities and Exchange Commission is pursuing to regulate XRP. A disturbing number of significant cryptocurrency investors, who are frequently referred to as whales, have been purchasing XRP at an alarming rate, as revealed by market figures. Whales are some of the most prominent cryptocurrency holders. In spite of the fact that the legislation that regulate the sale of XRP tokens are not yet fully understood, this is still taking place. Ripple has filed a cross-appeal against the United States Securities and Exchange Commission in reaction to the pressure that was applied by the SEC. In the immediate aftermath of the introduction of this legislation earlier this month, the company is attempting to provide a comprehensive summary of all of the pertinent legal issues that have been brought to light by the case. Ripple Labs Chief Executive Officer Brad Garlinghouse and Executive Chairperson Christine Larson filed a cross-appeal, and he commenced the process of submitting the notification to the court. Both of these individuals are responsible for the company's operations. In the second round of appeals that were presented to the Securities and Exchange Commission in August of the year 2023, Judge Annalisa Torres came to the conclusion that the XRP tokens that were being sold on secondary marketplaces did not qualify as securities. In the month of December in the year 2020, the United States Securities and Exchange Commission (SEC) launched legal actions against Ripple, saying that the company had sold shares without obtaining the requisite registration. There was no violation of any securities laws associated with Ripple's public offering of XRP sales to other countries. Ripple was ordered to pay a civil penalty of $125, as stated by the verdict handed down by Judge Torres. This was despite the fact that the lawsuit had been a significant topic of discussion among the Bitcoin community at the time. When it comes to acquisitions that were made by financial institutions, on the other hand, even though this was a huge decrease from the $2 billion that the SEC had asked, it was still a significant increase in compared to the $10,000 that Ripple had originally requested. In response to the notice that was distributed by the Securities and Exchange Commission in the month of October, Ripple made the decision to submit a cross-appeal, which was composed entirely of Doroti. According to the Chief Legal Officer of Ripple, the cross-appeal will assist prevent the repetition of missed opportunities to address incredibly critical concerns, such as the definition of an investment contract. This is something that has been recognized by the top legal officer. Making advantage of the cross-appeal will allow for the successful completion of this task. As a result of the filing of this cross-appeal, Ripple is providing a response to the appeal that was submitted earlier this month by the United States Securities and Exchange Commission, which included additional concerns. The outcome of this particular court battle has not yet been determined. It is currently being contested by the corporation that XRP comprises a securities offering, as claimed by Ripple, which has essentially entered the fight against cryptocurrencies. The Securities and Exchange Commission (SEC) is currently challenging the decision that was issued by the government. The two cases will now be evaluated jointly as a single entity as a consequence of this turn of events. By launching a cross-appeal, Ripple is attempting to reverse the decision of the court, which stated that the sale of XRP to investors did not violate any laws linked with the securities. Ripple's goal is to overturn the verdict completely. The verdict of the court that ordered Ripple to reimburse investors for a total of $125 million served as the catalyst for the production of this video. The CC has previously suggested a penalty of $2 billion in the past. Therefore, this penalty constitutes a significant drop in severity. Although it is a big sum larger than the $10 million offer that Ripple made, it is still a significant amount. As the events that are taking place continue to unfold, additional information will become available. According to a post that was made by Quality on XTCC, Ripple's chief legal officer Stuart Alder has apparently filed an appeal after failing to address all areas of their legal issue with the United States Securities and Exchange Commission. This is based on the fact that Alder has failed to answer all aspects of their legal issue. After then, this message sparked a sensation to spread throughout the Bitcoin ecosystem. When it comes to cross-appeal, on the other hand, it has recently been asserted that coins that are handed to developers and staff and that are exchanged on several platforms are considered securities. Since the decision that was handed down by the previous court provided him reason to believe that Ripple had a good chance of being successful. He is optimistic that the current court would lead the efforts of the Securities and Exchange Commission, particularly those efforts that are overseen by Gary Gensler, who is the chair of the SEC. According to Brad Garlinghouse, CEO of Ripple, the United States Securities and Exchange Commission is more concerned with attempting to create challenges and uncertainty inside the cryptocurrency business than it is with focusing on the creation of clear laws for the industry. Garlinghouse makes this assertion. Additionally, Garlinghouse declared that they are working toward the aim of securing the future of the Securities and Exchange Commission by finally putting an end to the second program of regulating by enforcement. This announcement was made in conjunction with today's cross-appeal, which was also made. The parent company of the cryptocurrency known as XRP has announced that it wants to file a cross-appeal in response to the appeal that was submitted by the opposing party. According to the announcement, the cross-appeal will be filed. The person who filed the petition is obligated to inform both the court and the opposing party of their intention to appeal a portion of the verdict that was found by the court. Despite the fact that this stage of the legal process is not the same as a typical appeal, it is nevertheless an important step in the process. The Securities and Exchange Commission was the entity that initiated the legal action in the first place. A ruling that was handed out by Judge Anelita Torres of the Southern District of Newark region is being appealed by both Ripple and the Securities and Exchange Commission. 13 federal appellate courts have, throughout the course of history, reviewed decisions that were handed down by lower courts. Stuart Alderode, chief legal officer of Ripple, stated in his statement that the business has followed with all due diligence by submitting a cross-appeal today as part of the cross-appeal procedure. He claimed that this was done in accordance with the procedure. A Twitter user by the name of X noted that in order for an investment contract to exist, it must include fundamental rights and obligations. He also added that the appeals would be heard by the Court of Appeals for the Second Circuit. Also, he stated that the appeals will be considered by the court. It has been decided that the Securities and Exchange Commission will not be appealing the verdict that XRP does not meet the criteria to be considered a securities pursuant to the Brody and Alderode test. According to Alderode, the chief legal officer of Ripple has expressed regret over the decision to designate the token as a security. This means that the firm has gone to the extent of implying that it regrets categorizing the token as a security. It is possible that the CC will make an effort to contest the conclusion that Ripple's programmed XRP sales and other dispersions did not constitute securities. This is a possibility. He is of the opinion that the Securities and Exchange Commission will once again fail to deliver on this topic. Furthermore, in the year 2020, the United States Securities and Exchange Commission launched a lawsuit against Ripple Labs, saying that the company had made a profit of $13 billion from the sale of XRP coins, which the SEC said were not registered. Both Christian Larson, who was one of the co-founders of Ripple, and Brad Garlinghouse, who is the CEO of Ripple, have been subjected to legal action against them in the field of securities. The decision that was made by a judge from the Anil Seder in August of 2024 was a split decision, and it has the potential to result in the classification of direct institutional sales of XRP as potential unregistered securities offerings. This is due to the fact that this category does not include programmatic sales or other distributions, such as those that are provided to reward developers and workers. It was determined that retail investors did not meet the requirements of the Howey test, which stipulates that investors must have reasonable expectations regarding the possibility for a company to generate profits. Due to the fact that it does not cover programmatic sales, retail investors did not pass this test. This was due to the fact that they were not aware of whether the XRP that they intended to acquire originated from Ripple or from another seller. A total of $125 in fines was imposed on Ripple Labs by Judge Torres as part of the company's sentencing. For the purpose of determining an estimate for these fines, the amount of money that was created via the direct sale of XRP was utilized. It is not appropriate to provide any kind of trading advice based on the information that is provided by institutions. In the event that any investments are made on the basis of the information that is provided on this website, we will not be held liable for those